Hello and welcome. My name is Chris Punongbayan. I'm the Executive Director of California Change Lawyers. I use he, him pronouns, and I am coming to you from the unceded territory of the Ramaytush Ohlone people, also known as San Francisco. I'd like to welcome you all to our last online event of the year, the second in the series on the Supreme Court. And this one specifically is taking a broad look at how the conservative legal movement is unraveling our rights. So I am really pleased to be presenting this program in partnership with the American Constitution Society and the Equal Justice Society. Thank you to both of these important organizations for co-convening today. I will be introducing our panelists, making some brief 1-minute remarks, and then asking our esteemed guests, I think what's on the mind of all of us in terms of what should we expect from this court. So our first guest is Dean Erwin Chemerinsky. He became the 13th Dean of Berkeley Law on July 1st, 2017, when he joined the faculty as the Jesse H. Chopra Distinguished Professor of Law. Prior to this role, from 2008 to 2017, he was the founding Dean and Distinguished Professor of Law at the University of California, Irvine School of Law. He's the author of 16 books, and his most recent are Worse Than Nothing, The Dangerous Fallacy of Originalism, and Presumed Guilty, How the Supreme Court Empowered the Police and Subverted Civil Rights. Welcome, Dean Chemerinsky.
Thank you. Great to be with you.
And our next panelist is Sam Spitale. He is the Director of Litigation at the NAACP Legal Defense and Education Fund, or LDF. He has extensive experience on the issues of capital punishment and voting rights. His representative cases include Buck v. Davis, in which the Supreme Court held that LDF client Dwayne Buck's constitutional rights were violated when Mr. Buck's own trial counsel presented an expert, quote unquote, who falsely testified that Mr. Buck was more likely to commit future crimes of violence because he is Black. In Northwest Austin Utility District Number 1 v. Holder and Shelby County v. Holder, Sam was an integral member of the LDF-led teams that represented Black voters who intervened to defend the constitutionality of the Voting Rights Act. Welcome, Sam.
Thank you very much. It's great to be here.
So we are all still reeling, I think, from the June bombshell decision in Dobbs v. Jackson Women's Health, which overturned Roe v. Wade. And suffice it to say that all eyes are on the court. But zooming out, it's important to remember that these decisions, and even who is on the court, are the results of a decades-long investment by the conservative legal movement to bring these states of affairs into being just the way that they are now. So I want to call in my own bias in this situation, and that's recency bias. That this very court looked at some high-profile cases just last week, Moore v. Harper related to the little-known independent state legislature theory, and 303 Creative v. Elenis, which addressed whether applying a public accommodation law compels an artist to speak or stay silent, violates the free speech clause of the First Amendment. So let's take Moore v. Harper first. Dean Chemerinsky, for our audience members who aren't steeped in this constitutional theory, could you explain what this is about? And also, if you could further comment on your takeaway from oral arguments last week, because I've heard some commentators remarking that it's not as bad as it could have been. So please kick us off.
Sure. Thank you. It's such a pleasure to be part of this conversation. Of all the cases on the docket this term, the one I'm most worried about is Moore versus Harper and the so-called independent state legislature theory. North Carolina is basically a purple state. It has a Democratic governor and attorney general and a Republican-controlled state legislature. Trump beat Biden in 2020, but only by 1.35%. After the 2020 census, the North Carolina legislature engaged in redistricting for congressional districts. And that's, of course, a process that went on all over the country. The North Carolina legislature, as I said, is controlled by Republicans, and they drew election districts so Republicans were very likely to control 10 of 14 seats. The North Carolina Supreme Court found that this violated the North Carolina state constitution. There couldn't be a challenge in federal court because in 2019 in Ritcho versus Common Cause, the Supreme Court said that challenges to partisan gerrymandering are non-justiciable political questions in federal court. But the Supreme Court left open the ability of a state court to find a violation of the state constitution. That's what happened here. The North Carolina Supreme Court appointed a bipartisan commission to draw nonpartisan lines, and not surprisingly, in November 2022, Republicans won 7 of those seats, Democrats won 7 of those seats, what you'd expect from a state that's so evenly divided. But the Speaker of the North Carolina House, Moore, went to the Supreme Court and said that the North Carolina Supreme Court should have no role here, that is left entirely to the state legislature for the final judgment. And that's based on a provision in Article 1, Section 4 of the Constitution that says the legislature of each state shall determine the time, place, and manner for elections to Congress. This seems so clearly wrong. Whenever there's a legislative power, it's always subject to limits by the Constitution and judicial review. It would have dramatic implications. It would then mean that a state could engage in partisan gerrymandering with no check. It would mean there can no longer be independent districting commissions for congressional seats, like exist in California and other states. I mean, even that the governor and state election officials couldn't play a role. And even more frightening, there's another provision in the Constitution, in Article 2, Section 1, that says that's the legislature of each state that shall allocate the electors in the Electoral College. If the court buys the independent state legislature theory, does that mean, say, a Republican-controlled state legislature could allocate the electors in that state to the Republican candidate, even though the Democratic candidate wins the popular vote, and there's a state law that says that's who should get the electors? From the oral argument, it was clear to me that 3 justices buy the independent state legislature theory, and that's Thomas, Alito, and Gorsuch. And we knew that from what they'd written before the argument. And it was clear that the 3 liberal justices, Sonora, Kagan, and Jackson, rejected. There's some questions from Barrett that I found encouraging in terms of her saying that if a state gives its power to the state courts, they should be able to interpret and enforce the state constitution. It looked like Roberts and Kavanaugh were trying to find some compromise. Roberts, towards the end of the oral argument, said, well, could it be that the state court would strike down what the legislature did and send it back to the court, not be able to take other action? That's frightening because it seems a recipe for stalemate. So I was neither encouraged nor discouraged by the oral argument. I was left to wonder, what are those 3 justices, Roberts, Kavanaugh, and Barrett, likely to do?
Thank you. And I want to encourage audience members to please comment on what you're hearing. And also, if you have questions for our panelists, please do leave the comments in questions in the comment box. So Sam, you have had extensive experience with protecting voting rights as an essential feature of a functioning democracy. Could you reflect on the significance of this case? And please share your takeaways from the oral arguments as well.
Yeah, thank you. And let me again say how wonderful it is to be here, and especially an honor to be sharing this virtual stage with Dean Chemerinsky. So I agree with Dean Chemerinsky that there is no case more important before the court this term than Moore, for the reasons that he stated, the real danger to our democracy that at least a strong ruling in favor of the independent state legislature doctrine would cause. I think that one of the things that's really important to underscore is that when there is the kind of partisan gerrymandering that Dean Chemerinsky talked about, that was the background for this case, there is often as well a racial discrimination component of that. And one of the things that the Legal Defense Fund emphasized in our amicus brief in the case was that voters of color are often manipulated in these extreme partisan gerrymanders. And that can be whether the partisan gerrymander is done by Democrats or Republicans. Either way, the map makers often manipulate voters of color. And while there are other tools that allow for challenges to racial discrimination and districting directly, and of course the Supreme Court has been weakening those tools as well, but often those tools are not sufficient to address the harms that minority voters face through partisan gerrymandering. So in addition to the sort of general anti-democratic nature of the independent state legislature doctrine, there is a particular risk for voters of color, which is something that I think is the first thing I would underscore about the importance of the case. And then, I don't really have much to sort of add to what Dean Chemerinsky said about the case and its significance, except to just really underscore points that he made, which is that partisan gerrymandering itself is so anti-democratic, and the court acknowledged that in Rucho, the idea that you could have a state where, under the plan that the legislature had proposed, have this purple state where one party was entrenched in power in over 70% of the seats. But then when you layer on top of it the idea that somehow state courts cannot perform the check and balance that is really a fundamental aspect of our understanding of what it means to be a constitutional democracy, it would just make it extremely, extremely inconsistent with our basic understanding of both democracy and the rule of law. And with respect to oral argument itself, I think the only thing I'll add is a more sort of procedural point, which is that one of the things that I think we have seen in case after case is not only how far this court is willing to go on the merits in entertaining some of these really extreme arguments, but how it is willing to cast aside the ordinary procedures to do so. So in Moore, one of the most basic ideas is that in order to preserve an argument, a party has to raise it throughout the litigation. That didn't happen in Moore. This independent state legislator theory was not actually presented or preserved in the North Carolina courts, and yet the Supreme Court was willing to consider it for the first time. And the compromise position that we've heard a lot about is also something that there's no reason for the court to address that, because the argument from the petitioner in Moore is just this extreme version of the independent state legislature doctrine. And if there is indeed a majority of the court to reject that, which I'm cautiously hopeful there is, in the ordinary course, they would just reject it and not consider anything else. But yet you see this interest in really going beyond that and entertaining additional arguments that may still be quite troubling, even if not as dangerous as the most extreme version of the theory.
Could you tease that out a little bit, the kind of the intermediate path? Because that was, I guess, a follow-up that came up for me is, if it's not the maximalist view, what would be still a loss, but I guess technically a compromise? What would it look like?
Well, my understanding of the argument is that the compromise position would be something like this, that a state court does have some role to play in interpreting state constitutions and state laws, even in the context of federal elections. But there would be this role for the federal courts and essentially the US Supreme Court to say that a state court had so far departed from the correct understanding of state law that it was no longer acting as a court and was essentially arrogating to itself legislative power. And I think that if that is the position the court adopts, the challenge, and you could see this in a colloquy with Justice Alito and Justice Kagan, is that if that really means that the Supreme Court would only get involved if a state court was essentially acting as a legislature, not even trying to act as a court, it probably would not be that dangerous, because courts don't really do that. If, on the other hand, anytime the US Supreme Court can say, oh, well, that state court was acting as a legislature because it wasn't following originalism, or it wasn't following originalism the way we would follow originalism, that is just essentially the Supreme Court being able to intervene whenever it thinks that a state court has misapplied the law. And that would be incredibly dangerous and not much of a compromise at all.
Thank you. Okay, a lot to unpack there, and there's still a lot left to go. So again, I encourage the audience to submit follow-up questions to our panel that we'll get to towards closer to the bottom of the hour. But let's shift gears to 303 Creative. Dean Chemerinsky, this case was one that many in the LGBT community were closely watching, especially in the aftermath of the Masterpiece Cake Shop case from a few years ago. And this was a carefully orchestrated case by the conservative legal organization, the Alliance Defending Freedom, and it is an interesting case for many reasons. Could you walk us through what 303 Creative is about, and what were your impressions from the oral arguments?
Lori Smith has a business designing websites in Colorado. She wants to expand to design websites for weddings, but she says because of religious beliefs, she refused to design websites for same-sex weddings. Colorado has a law that prohibits business establishments from discriminating on the basis of race, sex, religion, sexual orientation. Indeed, that was the law involved in Masterpiece Cake Shop. Smith filed a lawsuit in federal district court for a declaratory judgment that to apply the law to her would violate her free exercise of religion and her free speech rights. The district court and the 10th Circuit ruled against her. The 10th Circuit emphasized the compelling government interest in preventing discrimination based on sexual orientation. The Supreme Court granted review, but only on the question of whether applying the law to her would violate her free speech rights. It's interesting, the court did not take the religion question that was in the cert petition. My own sense of that is the justices are deeply divided over whether to overrule Employment Division versus Smith, the 1990 case that says that free exercise of religion isn't the basis for an exception from a law. In summer 2021, in Fulton versus City of Philadelphia, 3 justices urged the overruling of Employment Division versus Smith. Alito, joined by Thomas and Gorsuch. 2 others, Barrett and Kavanaugh, expressed sympathy and support for that position. And I think that the court taking the religion question here would have forced it to confront, does it want to overrule Employment Division versus Smith? I think it thinks it can sidestep that entirely by just focusing on this as a case about free speech. In Lori Smith's claim that this is compelled speech, the state says this isn't about speech. This is about conduct and about the state's interest in forbidding discrimination. I think what makes this case so important is there's always a tension between liberty and equality. Any law that prohibits discrimination, by definition, limits the freedom to discriminate. For decades, the Supreme Court has said stopping discrimination is more important than protecting freedom to discriminate. I think that this case, though, is going to have the Supreme Court saying that there is a freedom to discriminate, and it's based on free speech here, with religion being in the background. I don't see how the court can cabin this. What of the landlord who says it's against my religious beliefs to rent property to an interracial couple? Or what about the employer who says it's against my religious beliefs to employ a gay, lesbian, or transgender individual? Or what about the employer who says, from my religious beliefs, men and women shouldn't be in the same workplace, so I'm not going to hire any women or hire any men? From the oral argument, it seemed clear to me that this is going to be a 6-3 decision in favor of Lori Smith. Whereas for the prior case we were talking about, Moore v. Harper, I was very uncertain after the oral argument. Here it seems you've got a court that's going to be, I think, very likely to rule in favor of Lori Smith and against the Colorado law. And I think it's going to open the door to countless claims of people who want an exception from anti-discrimination statutes.
Deeply, deeply troubling. Sam, your thoughts on this? You know, I was going to remark about how Justice Brown Jackson raised the question of whether it would be okay for a white mall Santa to refuse to take pictures with Black children, along the lines of what the dean was talking about. And Justice Alito turned the hypothetical around by joking about a Black Santa and also about Black children dressed up in KKK outfits. Your thoughts on this, or about the case, or what the ramifications of a negative decision in this case would be?
Well, to take the last part of your question first, it was extremely disturbing to hear that part of the argument, as other parts of the argument, with Justice Gorsuch referring to essentially a course about following the law and the need to follow the law as a re-education course. This is a very, very troubling case for the reasons Dean Chemerinsky laid out. And to address the merits of the hypothetical a little bit, it also shows just how far the court has changed in some important respects over time. So in the amicus brief that we filed in this case at the Legal Defense Fund, we relied very heavily on a case, Piggy Park, where the court had unanimously and just easily rejected the idea that there was a right to discriminate that would allow a business owner to refuse to serve an interracial group of customers, and in particular to target Black customers in his discriminatory conduct, raising very similar arguments. And the court just said, they actually said it was essentially a frivolous argument, that the idea that there was this sort of constitutional right to discriminate. And now we are looking at a court, and I fear the same outcome is quite likely, that is going to, in a 6-3 decision, go the other way. I think the other thing that was really striking for me is because I think that even this court, there are at least some of the justices who are not quite ready to say openly, yes, we're not troubled by the hypothetical posed by Justice Jackson, and we're just going to create a general freestanding right to discriminate. So I think what they're going to say instead is, well, somehow this is not status-based discrimination. This is message-based discrimination. And Justice Kavanaugh actually was pretty explicit about that, saying, don't our cases teach that status-based discrimination is something that is properly protected by public accommodations laws, whereas message-based, that basically a business owner has the right under the First Amendment to sort of choose its message. And I think it's fair to say that maybe certainly much of the argument was devoted to questioning, suggesting that this isn't really about anti-gay discrimination at all. It's just about opposition to same-sex marriage, which is something totally different than actually discriminating against gay and lesbian people because of who they are, which is so demonstrably false. And I think, trying to sort of choose my words carefully here, but the idea that the Supreme Court of the United States, this body that is supposed to be the one that we all look up to as lawyers, not only in terms of the principles that it espouses, but in terms of the intellectual rigor it brings to the cases, was actually having a discussion about whether or not a business's refusal to provide content only for same-sex weddings is actually about anti-gay discrimination. It's just pretty remarkable.
We have such little time, I'm realizing, and so I do want to move to another very important case this term, a voting rights case, Merrill v. Mulligan, which is a redistricting case from Alabama. And Sam, we've already talked a little bit about redistricting in the Moore case, but it's sometimes hard to rally the masses around redistricting, let alone understand the legal issues. So can you break this case down for us, and what's at stake and what does it mean?
Yeah, absolutely. Alabama is approximately 28% of the people in Alabama are Black. I think about 62% are white. And yet there is this severe racial gerrymandering, severe racial discrimination in the way Alabama draws its legislative districts, both in the congressional and state legislative district, this case being about the congressional districts. And as a result of that, white voters in Alabama are able to monopolize power in 6 out of 7 congressional districts. There's very, very severe racially polarized voting. And so in 6 out of 7 districts, it means that white voters are going to win essentially every election, and Black voters have essentially no opportunity to elect a candidate of choice, meaning that Black voters, even though they represent about 28% of the population, only have the ability to elect a candidate of choice in about 14% of the congressional districts. So we at LDF, along with other organizations, filed a lawsuit under Section 2 of the Voting Rights Act, which is the key provision of the Voting Rights Act that the Supreme Court has not yet at least, undermined. And this is a nationwide ban on voting discrimination, including this phenomenon known as vote dilution, where voters of color, because of a mixture of a method of election or the way that district lines are drawn and how that interacts with racially polarized voting, are prevented from having a fair opportunity to elect candidates of choice. And the case went to a 3-judge federal district court because there were also constitutional claims and because it was about districting. And those cases go to a 3-judge court with direct appeal to the US Supreme Court. And that 3-judge district court, which included 2 district court judges appointed by former President Trump, unanimously concluded this is basically as straightforward of a Section 2 violation as you can imagine. Severe racially polarized voting, the maps clearly target parts of the state that are majority Black for disfavored treatment vis-a-vis parts of the state that are majority white in terms of the way that voters are cracked or packed, meaning the way that they are placed in district, and the way that communities of interest, sort of similar communities, are treated differently. And so the court held that this is a very straightforward Section 2 case and granted a preliminary injunction that would have required Alabama to create a second district where Black voters were either a majority or at least a substantial enough part of the population that they'd have a fair opportunity to elect candidates of choice. The Supreme Court stayed that preliminary injunction, which would have been in place for the 2022 election, by a vote of 5-4, with the most extreme conservatives being the 5, Chief Justice Roberts joining the moderate liberal justices in dissent. And then the court heard the case on the merits in October. The oral argument was interesting because the state of Alabama had taken very extreme positions that would have essentially abrogated Section 2 in its utility, at least, and would have suggested that Section 2 was unconstitutional. And I think it was clear that there was not a majority of the court to go that far. You had even Justice Alito trying to sort of help the state by saying, well, let's take a narrower version of your argument, which I think he thought might be more palatable to a majority of his conservative colleagues. What's very unclear, though, is what the court is going to do, given that I think it is not inclined to accept Alabama's extreme arguments. And to return to the point I made earlier about procedure, in an ordinary case, if the court thought that the party's arguments were not persuasive, it would not be appropriate or necessary for it to sort of search for other arguments to kind of save the party's position. They certainly would not do that if the roles were reversed here. But you did see the conservative majority, again, searching for some way to, I think, give at least some sort of partial victory to Alabama. But the reasoning that they might use, I think, is difficult to determine.
Thank you, Sam. And Dean Chemerinsky, is there any elaboration you'd like to make on this case?
I think that was a terrific presentation of the case. I just would put a larger context. I think the Voting Rights Act of 1965 is one of the most important federal laws adopted in my lifetime. One of the key things that it did was require that jurisdictions with a history of race discrimination voting get pre-clearance before any significant change in election practices. In 2013, in Shelby County versus Holder, the Supreme Court essentially struck down the pre-clearance requirements, so no jurisdiction needs to get pre-clearance. And states like North Carolina and Texas immediately put into effect the very plans where pre-clearance had been denied. Chief Justice Roberts wrote there, and one of the reassurances he gave us, well, there's still Section 2 of the Voting Rights Act that prohibits state and local governments from election systems that are discriminatory impact against voters of color. Congress amended that in 1982 to say proof of a discriminatory effect would be sufficient. There didn't have to be proof of intentional discrimination. In July 2021, in Brnovich versus Democratic National Committee, the Supreme Court 6-3 made it so much harder to prove that state and local regulations with regard to the time, place, manner of elections, where polling places are located, how absentee ballots can be turned in, violate Section 2 of the Voting Rights Act. The court made up criteria like considerations of voter fraud that had no relationship to the statute or its legislative history. But this case is then about how does Section 2 apply to districting? The Supreme Court has articulated criteria decades ago in a case called Thornburg versus Jingles. And overall, those have worked well. I worry that the court here is going to revisit Thornburg versus Jingles and make it much harder to prove that districting violates the Voting Rights Act.
Okay, so we spent about a half an hour going case by case, and we could spend the remainder of our time that way, but I do want to zoom out a little bit because I think we have a really firm understanding of what's at risk with just the three that we have gone into some depth on. But the court has also considered the affirmative action cases at Harvard and University of North Carolina, The court has looked at immigration and the state's ability to challenge federal policies in US v. Texas. The court has examined the Indian Child Welfare Act in Halland v. Brackeen. So my question is, what is your impression of the court so far this term? Has the court survived, as Justice Sotomayor stated herself in oral arguments last December, has the court survived the stench in the public perception that the Constitution and its reading are just political acts? Dean Chemerinsky.
Sure. Obviously, the Supreme Court has survived. It's still there and doing its work. But we've got to remember that the court has the lowest approval ratings of any time since they've been measured. Gallup poll in June had the Supreme Court with 25% public confidence, the lowest it's been. In July, there was an opinion poll by Marquette University that had the Supreme Court with 38% approval and 61% disapproval. I think there's a question of, if the Supreme Court continues in this way, what will it mean for the long term? At a time when our country is so politically polarized, what's it going to mean to have a court that's come down so clearly on one side of that divide and so far to the right? I don't know that the cases that you just mentioned will matter much in terms of the court's public legitimacy, but they're going to have an enormous impact on people's lives. Take the affirmative action cases. The two cases I think are likely to have the Supreme Court hold that the earlier decisions, Bakke, Grutter, and Fisher, are overruled, and that college universities can't engage in affirmative action. I think that's going to have a devastating effect on diversity in many college universities across the country. Some states have already eliminated affirmative action. California did in 1996 in Proposition 209, and we saw it was a devastating effect on diversity. In, say, UCLA and Berkeley, if you compare 1995 before Prop 209 and 1998 after it, the number of Black and Latinx freshmen fell by half. It took UCLA 19 years until 2015 to get back to its pre-1996 level of diversity. And that was a tremendous commitment and enormous effort. So the cases you mentioned may not undermine the court's legitimacy in the way that overruling Roe did, but it's sure going to have a detrimental effect on a lot of people's lives.
Thank you for that reminder, Dean. And Sam, your thoughts on the court so far this term and legitimacy and all of the issues that you want to bring into the conversation?
Ooh. So this is a hard one, especially hard because we are litigating before them a lot. So I want to be thoughtful about how I say this. But I think that the thing that is striking to me from the arguments in a lot of the cases that we've talked about is that I do think you can see that for at least some of the justices, that perception of legitimacy and the perception of whether they're following the rule of law matters. And I think that you see at argument justices suggesting that decisions that would effectively overrule prior precedent are actually not effectively overruling prior precedent. So in the affirmative action cases, Justice Barrett was suggesting that, well, perhaps essentially revisiting Bakke and Grutter would not constitute overruling precedent because there was a vague reference in Grutter to a 25-year sunset provision or sunset period, and aren't we almost there? You saw, as Dean Chemerinsky was talking about in the redistricting case, justices who I think are hostile to the Jingles case, that seminal case, searching for a way, from my perspective, to revisit the principles animating Jingles, but without actually saying they're overruling Jingles. And those are just two examples. And the reason I bring that up is that I think that it creates a really important opportunity and responsibility for all of us who are observing the court, who are participating in public conversations about the court, and who are advocating before the court, to say very directly that, no, these sorts of efforts to suggest that a decision which is fundamentally inconsistent with one of the court's seminal precedents in the area, but do not literally overrule that precedent by name, are just as inconsistent with the rule of law, the principles of stare decisis, and the court's own legitimacy as a decision like Dobbs, which had to openly acknowledge what it was doing.
Thank you, Sam. So this term has also seen, it was the first time that the court has had a Black woman among its membership, with Justice Ketanji Brown Jackson. And so I would like to ask both of you to reflect on what impact she has had on the court so far, in your estimation. Dean Chemerinsky?
Sure. She's obviously had an impact at oral argument. She's been a very aggressive questioner. We were talking about Merrill versus Milligan, which was argued the second day of the term, and she was very active in oral argument. And she's put forth, I think, a very strong viewpoint, rejecting the idea of a colorblind constitution. I think it's taken a long time to assess her overall impact. I think that having a different set of life experiences has the possibility of influencing other justices in cases. Many of the justices spoke about how Thurgood Marshall's presence or Senator Connor's presence influenced their thinking. I think one place where her replacing Stephen Breyer could make an immediate difference is with regard to criminal procedure. Breyer was often with regard to criminal procedure, and say Fourth Amendment cases, Confrontation Clause cases with the conservatives. And I think here Jackson's experience as a public defender might give her a quite different outlook. And the only thing I'd say about this is to remember that she's 51 years old. Right now, it's still a 6-3 court, and replacing Breyer with Jackson isn't going to make a difference in the most contentious issues. But she can be on the court for decades to come. And maybe 10, 15, 20 years from now, her presence will make all the difference in 5-4 rulings.
Thank you. And Sam, any observations about Justice Ketanji Brown Jackson so far?
I think the only thing I would add is about the nature of her question during oral argument that Dean Chemerinsky pointed to as well. And I think that, and obviously I do not know what is going through her head as she's asking questions, but I think it has been really remarkable from my perspective to see the degree to which she is so forthright and clear-eyed about responding to the kind of first principles arguments that the conservative justices are so frequently making. So to take a step back for a minute, I think that this court, more than any court, certainly since I've been paying attention to Supreme Court arguments, a number of the justices will skip past the precedent and go straight to first principles. If they're originalists, what's the original understanding? If they're textualists, what does the text mean? Whatever our precedent says. And so to hear the way that Justice Jackson has engaged with that and said, for example, you want to talk about the original understanding of the Reconstruction Amendments, let's talk about that. And let's talk about how absurd the idea that those amendments were designed to create some sort of colorblind approach to remedial legislation. And I think that from my perspective, it seems to be not only something that is important in terms of making the record clear, so to speak, but I think it's actually a strategic decision, or my sense is that it's a strategic decision to really sort of suggest to her colleagues, her more conservative colleagues, that the principles that they are advocating, they themselves have to recognize that there have to be limits to the principles they're advocating. And I think whereas Justice Breyer, his approach to try to influence his more conservative colleagues was to be very focused on, compromise is not quite the precise word, but to sort of look for ways to find common ground. And I think Justice Jackson's approach so far seems to be more to sort of engage with these first principles directly and show very clearly and publicly that some of the extreme positions that the conservative justices seem to want to take are just fundamentally inconsistent with the interpretive methodologies that they propose to be adhering to.
I will say it certainly feels vindicating to have Justice Brown Jackson state what, the purpose of the Reconstruction Amendments were, and to have her be as powerful a voice, an equal voice, saying what it really means, what originalism, would really lead us, what path it would really lead us down to, compared to how it's been, I guess you could say, distorted by some of the other outspoken folks on originalism. So I do want to talk a little bit about Supreme Court reforms. So it's just been controversy after controversy from this court, from Justice Thomas's wife, Ginny Thomas, and her political dealings, going back a few years to Justice Kavanaugh's heated confirmation hearing, all the way to the fact that 3 of the 9 Supreme Court justices were nominated by a US president who lost the popular vote. And 2 more, if you include the nominations by George W. Bush, who initially lost the popular vote. So there's so much here in terms of possible reforms. And I'm just curious what you think the top reforms should be, what should be the priorities? People have talked about court expansion, judicial ethics, term limits. Is there something else? What do you think the next step should be around court reform, if any? Dean Chemerinsky, please.
Sure. We've got to be realistic. Court expansion isn't going to happen in the next 2 years. The size of the court, as we all know, is set by statute, not by the Constitution. Congress could change it, but there's no way in the world that the Republican House is going to vote in favor of expanding the size of the Supreme Court. And even if the Democratic House had done in the last 2 years, it would have died because of a Republican filibuster. I think in terms of term limits for justices, I think that there's more of a bipartisan consensus for that, especially where prospective. My own view is it would take a constitutional amendment, and I just don't know there's a constituency that cares enough to do the work. But I think ethics reform for the Supreme Court could have strong support. To me, this seems a self-inflicted wound by the Supreme Court. The justices could adopt their own ethics code, like that applies to other federal judges. They'd also need to have an enforcement mechanism, because for all the discussion on ethics code, it's meaningless if recusal is still left to each justice to decide for himself or herself. And I would hope that if the court doesn't adopt ethics reform, Congress would impose this on the court. There's a chance the court could declare it unconstitutional, but I sure think it would not help the court's legitimacy for it to declare unconstitutional ethical standards applied to it that already apply to other judges.
And Sam, your thoughts on reforms?
So I'm going to punt a little bit on the question and sort of answer a little bit differently. I think that and pick up on what Dean Chemerinsky was saying, I think that this is not a solution that's going to happen in the next 2 years, given where Congress is. But, and there's some questions in the chat sort of about this idea generally. The Supreme Court can only be so powerful in unraveling our rights, to use the sort of title of this conversation, if the other branches are either aligned with it or not functioning the way that they should. Because while not across the board and not sort of perfectly, there are so many things that Congress can do to restore rights that the court is poised to take away. And we saw a great example of this just this week with Congress's essential restoration or I shouldn't say restoration because no one has yet taken it away, but with the court potentially poised to overrule the constitutional right to same-sex marriage, or Justice Thomas at least calling for that, Congress stepped in and passed a law that requires states and the federal government to recognize any marriage without regard to the sex of the people being married, and the same with respect to interracial marriage, which is another precedent that some are worried the court could interfere with. And so it's not quite the same as the federal right, but it does much of the same work. If Congress were able to address the situation and to get over the dysfunction in the Senate with respect to the filibuster, Congress could have largely, if not completely, restored the national right to abortion. And I think that with so many of these areas, if Congress and the president were in a sort of pro-civil rights state of mind, there is so much they could do to limit the damage from the Supreme Court. So I think, what I would say, without addressing the sort of reforms specifically, is just that there is an opportunity for all of us as citizens to address this, assuming that we can get over the gerrymandering and the other ways in which the rules are sort of stacked, by electing officials who are pro-civil rights.
Mm-hmm. I do want to shift gears a smidgen, still in the same general category of controversy, but just honing in a little bit on your impression about the leaked opinion in the Dobbs case. What are your thoughts about it now, and how have they changed, if at all, with regard to reports of another leak earlier in 2014 by Justice Alito in the Hobby Lobby case? Your thoughts on the leaks that seem to be happening. Dean Chemerinsky?
Sure. To me, what was most stunning about the revelations of the Hobby Lobby case wasn't that Justice Alito might have leaked the result, but the way in which the Christian right had insinuated itself into the Supreme Court, through the Supreme Court Historical Society, through private prayer sessions with the justices and the like. I think in terms of the leak in Dobbs, it was just extraordinary because you haven't had that happen before, where a whole draft opinion got leaked. But when I read it, I wasn't surprised that that was going to be the result in the case. I had no doubt from oral argument that was going to be the result in the case. I thought that the court might tone down more of the language from the draft opinion to the final opinion. I was surprised to see the court speak of its former colleagues by saying that they were egregiously wrong and their reasoning was exceedingly poor. I wouldn't talk that way about a former faculty member on this faculty, even if I felt that way. And remember, Roe was 7-2 and included 3 Republican-appointed justices. Casey was 5-4, and all 5 in the majority have been appointed by Republican presidents. But I think that the leak was just extraordinary because it doesn't happen. But I didn't give lots of weight to the fact, okay, so it happened. Doesn't change that much.
Sam, any thoughts on the leaks?
I don't have anything to add. I think Dean Chemerinsky said everything I would say and said it better.
Yes, thank you. Okay, so we did have a couple of questions in the chat. I just want to go back. There was a question from Steve, and this was regarding Moore. So dialing back to Moore. If the Supreme Court were to deny state court review in this case, what other functions assigned by the US Constitution to legislatures might be at risk of being similarly insulated from court review? Would either of you like to take that one?
A lot will turn on how they write the opinion. Of course, everyone's going to be interested in how they write about this provision relative to Article 2, Section 1, which gives to state legislatures the authority to allocate electors. What we didn't mention is that the independent state legislature theory has at least some of its origins in an opinion written by Chief Justice William Rehnquist 22 years ago yesterday on December 12, 2000 in Bush versus Gore, joined by Justice Thomas and Scalia. And I thought at the time it was a fringe theory. Even when it was raised in 2020, I thought it was a fringe theory. But if the court embraces the independent state legislature theory, then I think the question is what's going to mean for presidential elections as well.
Exactly. Okay, so we have just a little bit of time left. What are the top cases that you're watching for the remainder of this term? Sam?
I think that the cases that we have been the most focused on in terms of sort of racial justice and the court's threats to racial justice and democracy are ones that have already been argued. We will wait the decisions. There are a number of cert petitions and potentially significant cases that I think are going to be making their way up. And I think that, I don't know that they'll get to the court this term or not, but one of the things that we haven't talked about, because this is focused on the Supreme Court, is the ways in which there is also a conservative legal movement that has captured some lower courts. And so, for example, in the aftermath of Dobbs, that is going to come to the Supreme Court, and I think it's going to get there soon. There are going to be disputes about interstate travel. There's going to be disputes about medicated abortions, and states' efforts to, essentially disregard federal law. So I think those kinds of cases, whether it's this term or sort of shortly thereafter, I think are going to percolate their way up to the court. And then again, whether it happens this term or not, I don't know. But I think that whatever happens in the affirmative action cases, there's going to be a significant amount of litigation. So one of the things that was interesting is that previously the dissenters in cases where the court had upheld affirmative action had sort of advocated for plans like the Texas 10% plan, plans that were neutral on their face, but did seek to use some other sort of proxy to increase racial diversity. And now those kinds of efforts are under attack. And there was an effort to get the Supreme Court to review one of those cases and to sort of actually intervene in the lower court process, which had rejected the challenge. And that was rejected 6-3, but, again, sort of only in a temporary preliminary way. With respect to redistricting, in addition to the Merrill case, the court is holding a Louisiana case, which pretty similar facts, another LDF case. And so whatever happens in that case whatever happens in the Merrill case is going to impact the Louisiana case, and then a number of other redistricting cases. So, they're just these kind of categories where we're going to continue to see the impact and fallout from the cases that we've already talked about once they're decided later this term.
Thank you, Sam. And Dean Chemerinsky, what remains for you?
I strongly agree, and I think we've talked about so many of the major cases. I would add a couple. Biden versus Nebraska, which involves President Biden's authority with regard to the student loan relief. I think there's important questions there in terms of administrative law and statutory interpretation, but also underlying it is the standing of states to be able to sue. You mentioned very briefly Helen versus Burkine, which involves the constitutionality of the Indian Child Welfare Act. And again, there's some issues there about the ability of states to sue. There's issues in terms of the scope of Congress's power. There's also, should we regard tribal membership as a racial classification, in which case the court might look at it like it does the affirmative action cases, or is it a political status because it's sovereignty in a nation? There's already an important case in terms of the internet and social media, Gonzalez versus Google. It involves Section 230 of the Communication Decency Act that says that internet and social media companies aren't liable for what's posted. The issue is if a social media company, Google, uses an algorithm to decide what should get prominence, does that mean it no longer has Section 230 immunity? And if the court says that, the internet and social media as we know it will change dramatically. And I expect the court will take for this term one of two cases, most likely from the 11th Circuit, involving a Florida law, but there's also one coming to the 5th Circuit, a Texas law involving net choice, as to whether states can prohibit social media companies from engaging in content moderation. And it's very frightening to me to think if the court would do that, because we want social media companies to on their own engage in content moderation, such with regard to hate speech or child sexploitation materials and the like. So those are some of the things also on the docket.
Ooh, just very sobering overall, what's to come and what has come. So I guess I just want to close with something maybe aspirational and something that I think will maybe feed our souls a little bit, which is a broad question. So please take it in the direction that you will. But how do we keep bending the arc of history towards justice? And please, Sam, kick us off.
I think it's really important to remember that the Supreme Court has a lot of power, but it is not the only body that matters, even for litigation, and certainly for advocacy, legal advocacy more broadly. And there are so many ways in which, and other civil rights organizations would say the same thing, that even where the Supreme Court is, and even how challenging the federal courts have been, we continue to win both in courts and then victories in other kinds of, other forums and other kinds of advocacy. And I know it's the experience of, I'm sure, so many people, in other organizations listening to this conversation as well. And so I think just remembering that when, the Supreme Court maybe closes the door or leaves it open just a crack, there are always opportunities to find that window somewhere else that you can still see the light coming through, or to figure out a way to get through that crack. And I think it's been encouraging to see actually how many lower federal court judges have shown a real commitment to giving civil rights plaintiffs at least an opportunity to litigate their cases. We heard Dean Chemerinsky talk about the Brnovich case, which was indeed a really, really troubling case. And at LDF, we had filed a number of voter suppression challenges. The laws passed in the wake of the 2020 election and the big lie in many places, trying to make voting more difficult and targeting Black voters and other voters of color. And we got all these motions to dismiss, saying, look, after Brnovich, they made up all these new factors and they're more challenging now. And yet in every case, that we're litigating, at least the district court judges rejected those motions to dismiss and said, no, we need to still have a trial here. Or to at least have discovery. There are real sort of significant issues, and Brnovich may be a challenge for plaintiffs, but it's one that you can't decide on motion to dismiss. And I think that is really important, because when we have an opportunity to still have discovery in the litigation process, to develop facts, to show sort of what is really happening, we have a chance both to win the case, but also to kind of bring, the sunshine into the process. And so just even from litigation, I think that there's still a lot of ways to, keep that arc going in the right direction.
Thank you. And Dean Chemerinsky.
I was going to say three quick things. The first is exactly what Sam just said, and he said it so well. I think it is important to win in other venues besides the United States Supreme Court. He mentioned the successes in voting litigation in district courts, but there's also the possibility of expanding rights in state courts under state constitutions. I taught criminal procedure this semester, spent a lot of time showing how state courts have protected rights where the U.S. Supreme Court hasn't. That's not going to work in every state, but it can certainly work in some states. There's also the chance to win in the political process. Congress did just adopt an important law with regard to marriage equality. There's the chance to win at the state and local levels. Many states adopted laws after the tragic death of George Floyd, bringing about absolutely overdue reforms. So we need to look for venues other than the court. Second, we've got to develop alternative visions. We have to develop a progressive vision for constitutional law. We need to convince people that elections matter. Had Hillary Clinton won the 2016 election and she appointed those three justices, we'd be in a totally different place. Roe versus Wade would still be the law. Affirmative action wouldn't be in jeopardy. So we've got to have a vision that includes winning in the political process. And third, we've got to take hope from history. This is what I tell my students, that if you look at the sweep of American history, there's been such tremendous advances in equality and freedom. Obviously, there's an enormous way for our society to go with regard to racial equality. But if you compare what it was in 1787 when the Constitution was written, or 1868 when the 14th Amendment was adopted, or even 1953, the year I was born, when there were still Jim Crow laws in every southern state. We think of the advances there have been with regard to sexual orientation. Obergefell is just 7 years ago. And think about the advancement of rights. And so what I tell my students is that the arc of the moral universe is long, and it does bend towards justice, but only if they work to make it happen.
Mm. Well, I just want to ask for a virtual round of applause for our amazing panel. So please weigh in on the comments. Thank you so much on behalf of the American Constitution Society and the Equal Justice Society and Change Lawyers for joining us today. And special thanks to our panelists. This is it for the year for Change Lawyers, for our public events. We'll see you in 2023. Thank you all so much.